Hello everyone and welcome to Legal Aid New South Wales Law webinar on payday loans and responsible lending. My name's Dana and I'm here with Alexandra and we're both from the Legal Aid New South Wales Civil Law team. So we'd like to be talking to you today about payday loans and responsible lending, and I'll hand over to Alex at this point to take you through the purpose of the webinar and what we'll be covering today.
Thanks, Dana. The purposes of today's webinar is for you to better understand what payday loans are, the context in which they occur, and the law that regulates payday loans. This webinar will also provide information on who to make a legal referral to where you see clients with payday loan issues. These are the topics we'll be covering in today's webinar. What are payday loans? What is responsible lending? What laws apply? What are the obligations under the Credit Law and the Enhancements Act? Alternatives to payday loans? And where you can refer clients to for legal advice. So what are payday loans? Payday loans, also referred to as small amount credit contracts or quick loans, are a type of credit product that focuses on lending small amounts of money quickly. Specifically, a payday loan is a loan of up to $2,000 that must be repaid between 16 days and 1 year. Payday loans are usually repaid by a direct debit from a customer's bank account or directly from a paycheck. Payday loan companies focus on providing small amounts of cash to consumers quickly and make the process for applying for a loan easy. So what's the problem? Payday loans target vulnerable consumers who require small amounts of money fast, usually for essential expenses until their next paycheck. These consumers are often already in a situation of financial hardship. Payday loans contain large establishment and monthly fees. Consumers often struggle to pay off the principal amount of the loan as well as these additional fees. This leads to consumers being stuck in a cycle of debt, placing them in further financial hardship. Because of the nature of these loans, there are extra obligations that lenders must comply with before they grant a loan.
What are responsible lending obligations? I'll start by explaining the aim of these protections. The responsible lending provisions were introduced with the aim of preventing consumers being in contracts that are unsuitable and protecting consumers from predatory lenders. The key concept is that credit providers must not enter into a credit contract with a consumer if the credit is unsuitable for the consumer, and I'll explain later in the presentation what I mean by unsuitable. I'd like to talk now about the laws that apply to payday loans. The relevant legislation is the National Consumer Credit Protection Act, and I'll refer to this as the Credit Act throughout the presentation. Also, the Consumer Credit Legislation Amendment Enhancements Act, and for simplicity I'll refer to this as the Enhancements Act throughout my presentation. Both of these pieces of legislation are relevant to our discussion of payday loans. It's also worth keeping in mind the ASIC Regulatory Guideline 209, which is about responsible lending. So what are the obligations under the Credit Act for credit providers? Well, these obligations apply to all credit contracts entered into for predominantly household or domestic purposes. Before providing credit providers must make responsible inquiries about the consumer's requirements and objectives when getting into the credit contract. They must also take reasonable steps to verify the consumer's financial situation. So this might be getting payslips or bank statements from the consumer. They must assess the consumer's capacity to repay the loan without substantial hardship. And based on these inquiries, they need to determine that the credit is not unsuitable. So I mentioned the concept of a credit contract being unsuitable earlier in the presentation. And essentially, a credit contract is unsuitable where it'll cause substantial hardship for the person getting into the credit contract. If a credit contract is unsuitable or suitable, the credit provider needs to make a written assessment showing their reasoning for making a decision one way or another. And a consumer or their advocate can request a copy of the preliminary or final assessment from the credit provider. You should address your correspondence when requesting this assessment to the complaints contact listed on the Financial Ombudsman Service or Credit Ombudsman Service website, depending which external dispute resolution scheme the credit provider is a member of. By reviewing this assessment, you can see how the credit provider determined the suitability of the loan and get a better insight into your client's capacity to repay at the time. I mentioned earlier that the Enhancements Act is another piece of legislation relevant to our consideration of the responsible lending obligations on credit providers in the context of payday loans. So the Enhancements Act applies to small amount credit contracts or payday loans, and as Alex mentioned earlier in the presentation, these kinds of contracts are where the amount of credit provided is less than $2,000 and the term is at least 1 year but less than 16 days. It's important to note that the Enhancements Act obligations apply to loans entered into from March 2013. That was when this Act came into force. And the Act provides new responsible lending presumptions and obligations for small amount credit contracts. And again, the aim is to address the risk of consumers entering into a debt spiral. I'd like to talk a little bit more at this point in the presentation about what are the obligations under the Enhancements Act. So there's additional responsible lending requirements which are specifically applicable to small amount credit contracts. And these are, so firstly, the credit provider must obtain and review the bank account statements of a consumer for the previous 90 days when verifying their financial situation in respect of their payday loan application. And this is in circumstances where the consumer's income is paid into a bank account. The Enhancements Act also says that a credit contract will be unsuitable where the borrower is already in default under another payday contract, or in the 3-month period prior to the licensee making their assessment as to the suitability of that payday contract, the consumer has had 2 or more small amount credit contracts during that period of time. So in those circumstances, the consumer will be deemed to be only able to pay the loan with substantial hardship, and that's unless the credit provider can prove the contrary. So in this case, there's a presumption that the loan will be unsuitable and cause hardship where a person is already in default under a small amount credit contract, or they have had 2 or more small amount credit contracts in the 3-month period prior to applying for this payday loan. A small amount credit contract provider must not enter into a contract with a consumer if the consumer receives at least 50% of their gross income as payments from Centrelink, and the repayments in a payment cycle would exceed 20% of the consumer's gross income.
Thanks, Dana. So we're now going to discuss the case study of Leah and look at some of these issues in practice. So Leah's car broke down on her way to work. Leah took her car to the local mechanic. He said he could fix the car by tomorrow, but that it would cost Leah $1,500. Leah works part-time as an aged care worker where she receives $200 gross per week. She also receives Centrelink benefits of $400 gross per week. Leah needs her car to visit her patients. Leah knew she wasn't due to be paid for another week and didn't have any money in savings. She visited her local Cash For Me Now shop, which is a quick loan or payday loan provider in her area. Leah knew she could get a loan quickly from Cash For Me Now, as she already had 2 loans with them in the past 2 months due to her washing machine breaking down and a large electricity bill. She gave Cash For Me Now sales representative 1 month's worth of bank statements. She was then approved for a loan of $1,500, which she was required to pay back over a period of 12 weeks at $165 per week. Leah was granted these funds and set up a direct debit from her bank account. Leah's now 10 weeks through the repayment plan when she comes to see you. She's really struggling to get by and make these payments to Cash for Me Now, and she's in such financial hardship that she's unsure about whether she'll be able to pay her rent this month. So what advice could we give Leah about this payday loan? The first piece of advice is that Cash for Me Now have failed to comply with their obligations under the Enhancements Act to get 90 days worth of bank statements. The second is that this loan is likely unsuitable as Leah has already been granted 2 small amount credit contracts in the last 3 months with Cash for Me Now. Cash for Me Now should also not have entered into this credit contract with Leah, as more than 50% of her income comes from Centrelink payments, and these repayments amount for this loan are more than 20% of her gross income. So based on these 3 issues, Leah should get further legal advice about her matter, as she may be able to make an internal dispute resolution complaint with Cash for Me Now on the basis that this loan was unsuitable for her and that they have breached various requirements of the Enhancements Act. So it's important to note that there are alternatives to payday loans that we can advise clients about. This advice can be timely either before a client enters into a payday loan or advice about their options for the next time they require credit fast. So the first advice is that a client may be able to apply for a no or a low interest loan. If the client is on a low income, they may qualify for a no or low interest loan to pay off essential household goods or personal services such as medical treatment. These loans are far preferable to payday loans because they are low or no interest, which stops the client from being trapped in a cycle of debt to pay down the additional fees attached to payday loans. The second is that the client may be able to negotiate with a utility provider or creditor where they require credit for this reason. So if a client suddenly requires money to pay off an unexpected power bill, or they have fallen behind in a credit card payment, the best advice can be to contact that utility provider or that creditor to try and enter into a hardship repayment plan. This again avoids the client incurring unnecessary interest or charges to pay off the charges associated with payday loans. If a client receives Centrelink benefits, they may be able to apply for an advance payment from their Centrelink benefits with no interest charges. Clients can access information about how to apply for an advance payment through the Department of Human Services website. And finally, if a client does decide that their best option is to enter into a payday loan, then the advice will be to look at different providers to see what the additional fees and charges are for each provider. Ideally, the client would take that information and use the ASIC Money Smart calculator or the assistance of a financial counsellor to work out what the loan will cost them over the course of the loan's life, so the client can be better informed about what the fees and charges will be associated with that payday loan.
So what should your client do if they think that their credit provider has failed to meet their responsible lending obligations? So if you see a client who has a complaint about their payday loan, there's a couple of different things that you can do. The first thing that you can do is make an internal dispute resolution complaint to the payday loan provider. And I mentioned earlier in the presentation that you can find the complaint contact on either the Financial Ombudsman Service or Credit and Investment Ombudsman Service website, and that's who you address your internal dispute resolution complaint to. If your complaint doesn't resolve, then you can make a complaint to the external dispute resolution scheme that the payday lender is a member of. So that will either be the Financial Ombudsman Service or the Credit and Investment Ombudsman Service. Another option is to go to court, but if your client is considering going to court about the payday loan, it's really important to get legal advice first so that your client can assess the costs and benefits of challenging the payday loan in this way. As many of you will know, external dispute resolution through FOS or the CIO is free to the consumer, and they don't lose any of their rights to go to court if they're dissatisfied with the outcome through the external dispute resolution process. Consumers don't need legal representation to go to external dispute resolution for their dispute, but financial counsellors or lawyers can advocate for the consumer in this forum. One other place that you could make a complaint to is ASIC. ASIC regulates providers' compliance with responsible lending obligations. So if you're concerned about the conduct of a payday provider, you can make a complaint to ASIC through their online complaint form on their website. I'd like to talk now about where you can refer your client to for legal advice. On the slide, you can see the names of the consumer credit legal services which are available in each state and territory. You might also be able to refer your clients to the state or territory legal aid office or your closest community legal centre. Each state and territory legal aid office has their own website where you can find their contact details, and you can also find your closest community legal centre by using the national CLC website, which is www.naclc.org.au. I'd like to mention at this point as well that there is some law reform that is happening at the moment in the context of payday loans, which could see the introduction of some different and in some cases greater protections for consumers in respect of payday loan contracts. That legislation has not been enacted yet, so the law hasn't changed, and all the information that we've provided in today's presentation is current at today's date, but I expect that there may be some changes in the new year. I'd like to thank you for listening to Legal Aid New South Wales' presentation on payday loans and responsible lending.